One of the things we do here at Miller & Zoyce in our trial practice is we try to be as aggressive as possible in presenting our clients' cases. We do this, for one, because we have an ethical obligation to represent our clients zealously, and because we think that our approach adds value to our cases, and our results have borne that out over the years. One of the ways that we do this is with respect to defense medical experts. One of the things that usually happens in a personal injury case is that the defense or the lawyer appointed by the defendant's insurance company wants to have the plaintiff, the person claiming the injury, examined by a doctor of their choosing so that they can test the validity of the claims that are made by that person, whether they have a particular injury or whether it's related to a particular occurrence. And what we found over the years is that the insurance companies and their lawyers tend to use the same doctors repeatedly for this purpose, over and over and over again. We call them the usual suspects. Each of us at our firm has sort of their own mental checklist on all of these doctors, but one of the things that we think is true and that the courts have recognized is true is that it is possible for someone who has a financial interest to develop a bias one way or the other out of that interest. And here what we're talking about is doctors who repeatedly over years are paid very large sums of money by insurance companies for repeatedly serving as expert witnesses on their behalf and repeatedly providing opinions that often seem to be the same opinions. And one of the ways that we've tried to attack this problem for our clients in cases is we're very aggressive with these insurance doctors in trying to expose any bias that we think they have. Not that I'm saying that they all are biased, but that if there is a bias or a potential bias, it's my job to find out about it and to make sure my jury knows about it so that they can fairly evaluate any testimony that doctor gives. And one of the ways that we're on the leading edge of Maryland law on this issue is it is our practice and has been to subpoena records from these doctors to show how often they work for defendants and defense lawyers and defense insurance carriers, under what circumstances, how often they appear as expert witnesses, how often they give testimony, the sums that they charge them for doing this kind of work, how much money they make doing this kind of work for insurance companies, and how that number compares to what they make being a doctor. For example, I know of at least one doctor where I personally figured out that a quarter of his income one year, $250,000 of the $1 million he was making a year, was from the insurance industry. He was being paid to serve as an expert witness over and over again by the same you can edit these, right? Yeah, by the same lawyers and the same insurance companies and the same kinds of cases where he was giving the same kinds of opinions. And the way I was able to find this out is that we issued a subpoena. And oftentimes we find that doctors will fight these subpoenas. The leading Maryland case on this issue is called Follick versus Hornage. And actually it's two cases, both of which were handled by our office in the trial court. One was handled by me, one was handled by Rod Gaston. I handled the consolidated cases on appeal. And we took the case all the way to the Court of Appeals of Maryland, with the doctor fighting us and his attorneys every step of the way, to avoid producing documentation of the money that he was making serving as an expert for insurance lawyers and insurance companies. And ultimately what happened is that the Court of Appeals ruled in our favor. Now the Court of Appeals is the highest court in the state. And what the Court of Appeals held is that when there's a reason to believe that someone is acting as a professional witness, meaning someone who's been retained for money to act as a witness in a lawsuit, then the opposing party is entitled to discovery to figure out what they're paid for doing that, how often, by whom, and how the amount of money they make doing that kind of work compares to what they make in their regular medical practice. And not just that we're entitled to find it out, but that we're entitled to subpoena documents to find it out, because that's the only way that we know whether the answers we're being given are correct or not. And that opinion came out in 2010. And I know that in the last 2 years, the law that this firm made to help our clients is being used by lawyers all across Maryland to help their clients. And the defense bar, as far as I know, is still trying to come up with ways to use it against us. And it hasn't worked so far, and we're hopeful that it won't.